Okay, well, good evening, everybody. My name is Rod Escariola, and I'm a condominium lawyer with Gowling WLG. And welcome to CondoVirus Episode 3. And as we've done last week, this being the third episode, I decided that I would title it The Last Crusade, one of the greatest trilogy ever, I guess, in my humble opinion. So that's today's topic. For those who have been with us in the past, you know that what we've done, we've, in response to the COVID-19 pandemic, we've struck together an industry-wide crisis prevention cell to help the condominium industry navigate through these difficult times. And so what we have today is a panel of experts, as we have had in the past. You'll recognize many of the same characters, the same heroes ganging up against the same foe, and I'll introduce them right away to you. So first, there's Sandy Folds from Wilson Blanchard Management. Good evening, Sandy.
Good evening.
And we have Catherine Gao on behalf of the Association of Condo Managers of Ontario. Good evening, Catherine.
Hi, everyone.
And we have Denise Lash, founder of Lash Condo Law. She's also speaking on behalf of the Community Association Institute of Canada. Good evening, Denise.
Good evening, Rod.
Graham McPherson from Gowlings. Good evening, Graham.
Hi, everybody.
And we have David Plotkin, also from Gowling WLG. Good evening, David.
Good evening, everyone.
Two more. Jason Reed from the National Life Safety Group. Very lucky to have him tonight. Hi, Jason.
Good evening, everyone.
And finally, we have Justin Tudor from Keller Engineering. Good evening, Justin.
Hey, Rod.
Okay, so we have a very full agenda tonight, and as we've done in the past, there's going to be a lot of information. We're going to try to condense it. We try to give you practical information, not just too much blah, blah, but really information that you can use. And so we're going to cram as many answers as we can. We may spill over slightly over an hour because we just have such a full agenda, and hopefully you can stick around until then. As we had in the past, there's a chat channel. So for those of you who are familiar with it, feel free to chat between yourselves or share questions. You can access the chat channel either to the top or bottom or side of your screen. If you move your mouse, you'll get to see there's a green bar, and the green bar will get you to be able to activate the chat. We ask you to please focus on what we say, because often we get questions and you miss the question because you were busy chatting, and then you feel disappointed because you feel we have an answer. So try to do both. Try to do two things at once. Naturally, we can't answer every question that you have, and we regret that, but we've received many questions from you. We're gonna try to focus on the main questions that are repeated throughout. Please keep in mind that we're broadcasting this out of Ontario, and so most of our references to legislation is Ontario-based. If you are from a different jurisdiction, you'll have to adapt our reality to yours, or vice versa. And keep in mind also that the information we provide you today is valid as much as possible as of the date of this broadcast on April 1st. As some of you will watch this later on, because we'll upload the information to our website, the webinar to our website, and so some of you may watch this later. Please keep in mind that the information changes on an hourly basis. Now, most importantly, keep in mind that the information we provide you today is general in nature. It may not necessarily apply to your specific situation. It's very important that you seek advice from professionals that will tailor the information and adapt it to your very specific set of circumstances. Okay, so that was the waiver, if you've ever recognized one. The last thing I'll say is that this webinar is recorded, and as I said, we'll upload it on the Condo Advisor site, condoadvisor.ca, and you'll be able to watch it again for your viewing pleasure for weeks to come. Now, let's start, as we did in the past, with an update on any sort of recent changes that may have taken place this past week. And so maybe I can ask David to discuss the new wage subsidy program introduced by the federal government this week. Does that apply to condominiums, David? What can you tell us about that?
Thank you very much, Rod. So this came out very recently, and Minister Morneau just provided some further details today. And so the Canadian Emergency Wage Subsidy, this is different from any previous wage subsidies that were discussed. There was a previous 10% one a few days back. So this is for a subsidy equal to 75% of wages for any employee up to $58,700, which translates to about $850 a week per employee. The program is apparently available to any type of employer. So this is individual, partnership, corporations, and expressly nonprofits and not-for-profits as well. So while we haven't had official confirmation of condos, it would seem that this would fall under that as well. There seems to be almost no exclusions. In order to qualify, an employer must demonstrate it has suffered a reduction in gross revenues of at least 30% in the month of March, April, or May, compared to the same month in the previous year. How this is going to be calculated, what falls into it, is all to be determined in the coming weeks. This will all be run through the CRA portal. So if you're not signed up for direct deposit, that would be a good time now to do so. The minister hopes to have the portal for this program set up in 3 to 6 weeks time. And for independent contractors or self-employed, this is the only exclusion. Those individuals would not be included in this program, but could still apply to the emergency response benefit. That's the $2,000 a month for those who have lost income because of the situation.
I guess we're still looking into whether or not that would apply to condos. I realize there's no exclusion, but it may be, we may not be included. Well, first you need to have employees. You've indicated that. And second, you would need to demonstrate that there's a loss of revenue. And that's perhaps where the challenge will lie. I sure hope that most corporations are not going to suffer a 30% reduction in the revenue. It's going to be a different problem if we get there, but I think it's something that we're keeping our eyes on. Do you have any information about hydro rebates, David?
For sure, yeah. And on that wage subsidy, for sure, thinking of it from the property management perspective would be helpful. Because yeah, as you mentioned, I mean, the 30% reduction in revenue probably doesn't apply in the condo context. As for the hydro, just a reminder that as of March 24th, the provincial government temporarily for 45 days so far lowered the rates to the off-peak hour rates for all 24 hours of the day at 10.1 cents per kilowatt hour. So this can save both unit owners and the corporation who are, when they're for their hydro rates of the common elements, up to half of the bills, because on the on-peak periods, it's about 20 cents per kilowatt hour. There's no confirmation yet in whether after the 45 days that will be extended, but that's the situation that we're at right now.
Wonderful, David. Thanks so much. Now, the first topic we're going to tackle is deals with capital projects. And we're very lucky to have, indeed, one of my favorite speakers on the panel tonight. Always full of very good information, extremely knowledgeable engineer with Keller Engineering, Justin Tudor. Now, he's just told us that if you ever see his picture freeze, if he puts another picture and you don't see the live feed, it's because he's drinking beer, apparently, and he doesn't want you to see that. He just told us that a minute ago. So keep an eye on your screen. See how focused Justin is. Justin, the first question I have for you is this. There's a lot of capital work that's been, I mean, we're approaching, work season in many cases. And a lot of us are getting conflicting signals. For instance, on the one hand, the province has included construction in its list of essential services. But on the other hand, many of us are hearing that we should postpone all non-urgent work. And by non-urgent work, we're looking at work that's required to preserve safety and security, or work that's required to prevent damage to property. So obviously those, without a doubt, they have to go forward, these projects. But what is it? I mean, should capital work be postponed? And how do we tackle this?
Yeah, every contractor is thinking that not only they're essential, but they're totally safe right now. That's why we're being bombarded with emails talking about how safe they are. So in my opinion, non-urgent work feels like non-urgent work. And if you have to decide between the government saying all residential construction is essential and public health saying defer all non-urgent work if possible, side with public health. Non-urgent work is exactly what you say. If it feels like not doing it will be unsafe, you have to fix the balconies. If it feels like deferring the work will render it unsafe in a very timely nature, you should do it. That means knocking off concrete that's about to fall. Do that in a safe manner. Or if the operation of the building will be significantly affected if you defer the work even temporarily, you should be considering that urgent. In the idea that if you need to replace the chiller before the summer when it gets really hot, you should still be replacing the chiller. The plan on this, the key factor is urgent work if possible. If you haven't signed these contracts for the fence replacement, or if you haven't signed the contract for the minor roof maintenance package that isn't actually going to cause some leaks, you should defer those as much as possible because they don't feel urgent. However, if you've already signed a contract or you're midway through a project, the issue can become more complicated.
Okay, and so how do you deal with that? If you have in fact already signed a contract and it's set to start or in the middle of it, what do you do? How do we deal with that? I mean, do you postpone it? And wouldn't there be some maybe contractual sort of considerations to keep in mind? I mean, perhaps even in some cases, I assume the contractor perhaps doesn't want to come for whatever good reasons, but in other cases, we hear that they actually want to come and they want to continue with the work.
Mm-hmm. Absolutely. This is about not throwing the baby out with the bathwater, not canceling projects that could reasonably and safely proceed just because you want to slow down work right now. There's just 4 key factors to consider when you're doing this. One is safety. We believe that everybody understands what's going on. The contractor, the owner, everybody should be able to come to a reasonable agreement about an interim delay if necessary. The first step is safety. If the owners can't be safe, if the contractor can't be safe, then you got to put a pin in this. Owners not being safe looks like if we're going into units, if we're replacing windows, if we're repairing fan coils, it doesn't, consider your contractual language, but have a conversation that looks like we're going to defer this. If the contractor isn't sending you the email saying they're going to be doing what's right, then they're not committing to new protocols that you think are reasonably safe for the contractor. If, though, the work is outside, it has limited interaction with each other and with the owners, it's perhaps checked. And then you need to move on to the next consideration, the impact on the residents. Certainly, if you had planned a parking garage project that you're engaged in or halfway through because winter prices were right, now you might have 30 or 40 families quarantined and twice as many self-isolating in a building where they all plan to be working during the time. These factors have to be considered. If a conversation comes up that where the owner decides and the contractor are okay with deferring the project another month, that's a reasonable approach. However, you have to keep in mind, just because the inconvenience has increased, that doesn't necessarily mean that it should be deferred out of hand. It certainly doesn't mean that it's unsafe. These factors get a little more complicated when you think about something like an asphalt project, where you have more cars at home, more people in their driveways, less access. So these factors have to be considered in that order: safety, then impact on residents. Then you have to look at your language. Your contractual provisions are going to really guide what you can and can't do if you can't come to a reasonable agreement with your contractor. So look at your provisions, figure out what's possible. And the fourth factor in determining whether you're deferring a project is really to consider the cost of this potential deferment. Are you tied into this price? Is it going to increase in the next 60 days if you don't accept it? What is it going to look like in Ontario when we have such a short construction season as it is, and now we only have 2 or 3 months of a very busy summer when everybody gets going? What are the costs of delaying this a full year into 2021, where there could be twice as much work and half as many contractors? I don't know the answers, but you have to think about safety, impact on residents, your contractual requirements, and the cost of deferring these projects.
Okay, I was going to ask you if you had a magic crystal ball to tell us what does the future look like for us.
It's all
messed up. Yeah, it's going to be busy, not too busy now, but it's going to be hectic later. So maybe with a rapid fire kind of approach, Sandy and Justin, feel free to jump in. I'm going to ask you, it's almost a yes or no answer, but Sandy, landscaping and spring cleanup and lawn maintenance, we go ahead or we stop it?
They should go ahead. They don't have to have contact with residents. All the landscapers are traveling in separate vehicles. They can sanitize their tools. And if they don't, our lawns and gardens are going to look like hayfields, in a
Right.
few months. So I'd say
But,
yes.
okay, window washing?
I'd say for the most part, yes, as long as it's, on high rises, it's done from the roof. They have very little contact with owners when they're on swing stages. So yes.
Okay. The flip side to that may be this. I mean, and we're going to talk about the kind of work that has to stop in units, for instance. We're sort of encouraging owners to stop the renovations inside their suites because we don't want people to come in and out. And if while we're telling them to hold off on their work, we have our own contractors come in for work that may not feel urgent. I could see how people will say, well, what's that? Like you're sort of approaching it with, they're treating us differently here. But the flip side, of course, is that by May or by June, you may not be able to see through your windows. So you got to balance that.
And if you wait till June or July, you may not get a chance to get contractors in to do that work.
Right.
How about garage? Today, go ahead.
What about garage power washing?
That's one that can probably wait. I really don't think we want hundreds of residents having to move their cars out for garage power washing. Many of them will be self-isolating and can't move it anyway. So that's probably one that should wait.
Yeah, and somebody, John from Ottawa on the chat line said about the window washing, and he's right. I mean, a lot of their work may require that they transit through common elements. They may have to take the elevators, they may have to go to the roof, they may have to have access to the water supply and so on and so forth. So maybe one to consider there. Sewer cleaning.
That's probably safe to be done.
Yeah, I think it's a good idea. One question that comes often is this: what about pools? And I'm mainly referring to exterior pools because by now I hope you've all closed down your interior pools. But what about exterior pools? And I mean, the pool season is upon us. Do we need to open them? Do we need to maintain them? What would you do, Sandy?
Well, there's another thing. If we don't open the pools, the pool companies are worried about West Nile virus. So their recommendation is, yes, get your pools open, just open so that they're ready to go, but not for resident use yet until the government so dictates we can.
Okay. I'm going to switch topics briefly here. I'm going to talk back to you, Justin. Reserve fund studies. Should we proceed with those? Should we continue and get them done, or how do we tackle this?
Well, it's important to remember there's functionally two types of reserve fund studies, one with a site visit, one without a site visit. If you're in a year without a site visit, those keep rolling along. Your reserve fund provider, if they're working from home or if they're working from the office, can still roll with that, and through these tools can communicate with the boards. Your class 2s or your class 1s that have a site visit component, it's important to remember that the site visit isn't necessarily the be-all end-all portion of the reserve fund study. Sure, it's a component, but these things can roll along. We're not expecting there not to be a requirement to do a reserve fund study in the years that they're coming. And if you're up against it, provide a reserve fund study, and you have to have an engineer or a reserve fund planner go to site. Engineers have been deemed an essential service. This can be done safely, but mitigate it. Defer this for as long as you can, and if you have to attack it, have a safety plan on it. But you can certainly roll with these provided you're smart about it.
Okay. Another question that came up, and I hear this quite often, I'm going to ask you, Justin, first, and then maybe Denise, you can give us the legal perspective, but some corporations are concerned with cash flow, and they fear that maybe some owners won't be able to pay their common expenses. And so the question is this: should we consider delaying or deferring our payments, our contributions into the reserve fund?
Yeah, my first thought is, as you say, be careful. There's a lot of debate about this. It's always been my position that boards have a responsibility to have a plan, publish that plan, and follow that plan. And you can't modify it without going through all the appropriate steps, including notice of future fundings, and that should be really considered on an individual basis. But what I'm really trying to stress too, it should be about a real concern. You shouldn't just want to. This shouldn't be a conversation you even start if you don't have real concerns about putting decreasing costs, not just in case of.
Right. Denise, anything to add to that? That was pretty complete.
Yeah, not really. I think that's quite accurate. I mean, the only thing is if a corporation wants to change the way that they're funding the reserve fund, they have to change the reserve fund plan. And there should be good reason for doing so. And that's the only way that they can legally do it correctly.
Right. Okay. Maybe one last question. I'm not sure if you touched upon it, Justin Tudor from Keller Engineering. What about reserve fund studies that are underway right now? Is there maybe flexibility as to how we would finance them? Like, does that go into the equation, into the discussion?
Well, I don't think there's flexibility that didn't exist before. However, reserve fund planners are certainly going to be looked to be creative in how they structure their funding models within the window of adequacy that already exists in the legislation. What this could look like is if there is expected if you're doing a reserve fund plan, you might look like a lower contribution in the first year, but increased in the next two if that's the planner's definition of adequacy, increasing only by inflation after the first 3 years, which it's mine and is a commonly understood definition.
Okay, well, that's it. Justin Tudor from Keller Engineering, thank you so very much. Stick around if you want. If at one point in time you want to pipe up and you have something to add, please do so. And to the viewers at home, if you see the image freeze and there's a different image being superimposed, we know that Justin is having a beer. Thanks so much, Justin. Really appreciate it. Next topic, we're going to switch now to Jason Reed. Jason from National Life Safety Group. And Jason is going to introduce what I've called the Safety and Security Planning Tracker. This is an incredible document. We've posted on our website, and hopefully some of you had a chance to download it. It's a very comprehensive tool that will help you plan and identify topics of discussions with respect to safety and security. So, Jason, can you explain to us a bit what's the document, what's the purpose, how does that work exactly?
Absolutely. So thank you for having me. First of all, I've had the opportunity to participate in several webinars, and I've had the opportunity to participate in several little tabletop exercises focusing primarily on the commercial high-rise industry, but all of them are applicable with managing condominiums during the COVID-19 response. So really why this was developed was we took all the things that we're considering in commercial high-rises, and as you know, they're quite similar to residential high-rises. So we took that same format and applied that to a document that you can actually download, print, and handwrite in, or download and track your board's decisions and actions and considerations. For example, over the last 3 weeks, I guarantee boards and property managers have had discussions where decisions were made and they moved forward with that consideration, or they said, let's hold off on that consideration right now. This document was created so that boards and property managers can have a running log of their considerations and their considerations. And the log is done through the lens of 4 pillars: fire and life safety, security, occupational health and safety, and emergency management.
Okay, and I think, Jason, I think I've managed to put it on the screen so people can also see it at the same time. And we see that you've divided just exactly the categories you've described. We see the first one is occupational health and safety and all the other ones. And so now just keep in mind when you're describing it that we actually get to see it on the screen.
Yeah, absolutely. If you actually go to page 5, I'll walk you through an example of where I find the value of this. So I encourage you to book a virtual meeting with your board members and your property manager and walk through this. Take 45 minutes and walk through each one, because here's one of the concerns that municipal, federal, and provincial governments have had problems a year down the road from an incident like this, where they've taken a lot of good steps, but it's the tracking of that decision making hasn't been spectacular, if you will. So one of the things that I think that we can offer to the communities that manage high-rise buildings is a document to track those things in case you need that information a year from now. For example, occupational health and safety compliance, common area cleaning, and high area touch points. I think it's important that you actually document not only when you started additional cleaning, what direction did you give staff and what materials are you cleaning, including lunch areas for building staff, including, I would document the date and times of these cleanings. For the simple reason is you want to make sure you're providing evidence of actually completing some of these things. We do an awful lot in a 24-hour period. I'm just suggesting that, how do we document all this so that we can review this later on?
Okay. Did you want to try a second example? I'm not sure if you had planned on doing that, or
I do.
Okay. Bring me
Vertical
to the page.
community, page 7, vertical community safety. So in our last webinar, we had still discussions where condo boards or some condominiums had not shut down all of their shared amenities. And I think it's vitally important that we document whether the decision was made to close or whether the decision was made to open, but it's also important to document why they made those decisions, because trying to reflect on that 12 months from now or 6 months from now is going to be extremely difficult. So this allows you to do that. So that's just another example here. So by now, all gyms, spas, and saunas should be closed. Your playgrounds, your exterior pools, all of that should be closed. I think it's important to document when you close those and why you close them. For example, you close them because of public health guidelines or a public health recommendation, and that's very important. Another example would be page 8, again with respect to security. So here's another consideration for the board to review. You know, restricted travel has already occurred with respect to the province of Ontario's and the City of Toronto's declarations. So what I'm recommending is that you issue your security guards and your building superintendent and your cleaning staff a letter that says they come to work during this shift and they are deemed essential in my building, and they have a document from the building owner that says they're supposed to work and travel. What happens in the event that further restrictions are entailed? Our staff already have this document. It's not an official document, but at least it's something that I can provide to officials and say, yep, no, I'm an essential service. I'm working at this building. I'm traveling to this building. It's something that building owners can do and security service providers can do to ensure that there's no delays to the work staff getting to your building for your shift. That's just one example.
Yeah, that's a good example, actually, because right now in the Ottawa area, we've just been advised a couple of hours ago that they would restrict movement between Ottawa and the Gatineau side, the Quebec side. And so a lot of managers are now trying to put together these kinds of letters because there's a lot of movement. I mean, your concierge or your super may live on the Quebec side or vice versa. And so a lot of these letters are now being drafted as we speak to help for that, to facilitate the movement. Let me ask you, unless you have something else to say about the document, I would ask you specific questions that are a bit outside of the document. Anything else about the document, Jason?
I have one more on the security side of the document.
Sure.
Out of the 10 property managers I've spoken and boards I've spoken to today, the good majority of them have reduced their patrols. So where the concierge would get up and do a 15-minute patrol every 4 hours or 1 or 2 patrols a day, whatever your patrol routes are. One of the things that I'm recommending is that the board and the property manager really focus on that security guard conducting a virtual patrol every 3 to 4 hours. And it should be documented. And how do I conduct a virtual patrol? I have at my disposal a console system with many CCTV cameras. I should be utilizing them to their full potential and scanning the entire area of Zoom for that camera, and then moving on to the next camera, and then moving on to the next camera. And in about 15, 20 minutes, I can actually patrol all the areas with the cameras and document that. And I think that's really vital, especially when we're trying to consolidate the core responsibilities of that person at that desk.
Right. And these kinds of patrols that you've just described, actually, and this brings back to my military background, you have to do it in a very deliberate way. This is how you sort of scrutinize the horizon when you're looking for any movement. You got to do it in a very organized and deliberate way, and always sort of the same way. To avoid skipping over a screen or whatnot. If you do things always the same way, you're less likely to miss something. Let me ask you a few questions here. Let me see if I can go back to the slides. I'm not sure if I'll be able to do that. This share. Okay, quick questions, Jason. from the National Life Safety Group. What about annual fire inspections? Do we proceed with those, or how do we tackle these?
So annual inspections are required under ULC requirements S536. And quite simply, fire inspection and technicians, service providers have been deemed essential services across Canada. It's understood that the fire protection and inspection technicians, while they're on site, they're typically not engaged with residents or building occupants or employees unless they're doing in-suite inspections. So let me preface that just a little bit. So while on site, they typically have limited contact with building staff and occupants. They're able to maintain that social distance. And those two technicians who are doing your annual inspection typically communicate via two-way radio. Service personnel are obviously following the public health and social distancing requirements as well as their own employer health and safety requirements. So in that CAN ULCS 536 requirement, there is some language in there that says we are permitted to miss certain areas of the inspection due to not reasonably accessible, such as inside resident suites and inside tenant spaces for commercial and retail buildings. So within the language, it allows us to miss areas within that annual inspection deemed not reasonably accessible for a period of 2 years. So that's very, very important. When we look at what I'm recommending, I recommend that these systems, all your systems have to be inspected as required in your building. The fire code still complies, but I am suggesting that we use that language under CAN ULC 536 to continue with the annual inspections, but delay or postpone the in-suite inspections.
Okay, and that's answering one of the questions we had online, I think from Nancy actually. So that's good timing. And so, what about fire drills? Do we do these? And the question I hear often, and I can't wait to hear your answer. Do owners get involved in a fire drill, or do we round them up? How does that work?
So building owners are required to make sure that they run fire drills in all buildings in Canada. In Ontario, we have a requirement for high-rise residential buildings only to hold quarterly fire drills, and that requirement is for building supervisory staff only. So most buildings just have an annual fire drill requirement. They ring the bells, people get out, they familiarize themselves with the stairwells, they identify that, geez, I can handle this, I have no concerns, I get out of the building, I remain 350 feet away from the lobby, and I wait to get called back in. In residential buildings in Ontario, there is no requirement to do an annual fire drill with building occupants. However, there is a requirement for building supervisory staff, concierge, property manager, assistant property manager, security guard, building superintendent, to participate in quarterly fire drills. Now, there's been a lot of confusion on what's a quarterly fire drill. Quite a number of boards or property managers believe that the service provider comes and does my quarterly fire drill because they pull that pull station every once in a while and they ring the bells. That is not a fire drill. A fire drill in a residential high-rise building is required every 3 months. And what it entails, quite simply, is, if I'm at my 3-month period, I come in, I find out my staff that are on duty, I typically gather them around, and I walk through a tabletop drill. For example, what might I ask my staff? Hi, building superintendent, please show me where the main shutoff valve is for the sprinkler system. The superintendent walks me downstairs, takes me to this room, shows me the valve. I ask him or her, do you have a wrench to shut off that valve? Superintendent goes, oh, well, I knew where it was. I got to find the wrench. Good. Now I, as the building owner, document that fire drill. I had a fire drill. I asked him where the domestic water shutoff was. Didn't know it, or knew it, but didn't know where the wrench was. I found the wrench. I bolted it up to the top of the wall in the sprinkler room so it's readily available moving forward, and have eliminated that concern. And when I document that, that's an actual fire drill. I'm not suggesting that you only ask them one question, but I am suggesting that's the type of fire drills that are required for residential high-rise buildings on a quarterly basis. For example, concierge. I want you to practice or show me where you get the verbiage to announce on the fire alarm system and the emergency voice communication system. What do you say when there's a fire alarm? If the concierge says, I don't know, it's posted in the sprinkler room or in the fire alarm room, take me there. Show me what you're reading.
Right.
That's the kind of example of how we do a fire drill. You should not be ringing the bells. You should not. Because unfortunately, when we do that, we're desensitizing residents within the building with, yet again, another fire alarm that I'm not supposed to do anything with. So do I believe fire drills should be continuing on a quarterly basis? Yes, absolutely. Specifically with this heightened attention or focus on building safety while we're all inside our homes.
Right. Okay, let me switch channels because we're running out of time, Jason, and I want to use you to the full extent of your presence here. What about gathering information pertaining to infected occupants and whether or not we should somehow update our PRA lists? What's a PRA list, by the way?
So a PRA list is a list required by all residential building owners to maintain at their property that outlines a list of people who live in their building who may require special assistance during evacuation. Okay. So that could be anything from a physical, mental, whether it's temporary or permanent. If I've broken my leg skiing and I'm using a cast, I am on that list. And typically the PRA list is presented to the fire department as soon as they walk into your building. And they know now all the PRAs on the floor in alarm. So if the fire alarm's on the 10th floor, I immediately get a list of the PRAs on the 10th floor. And those, from a tactical firefighting perspective, are the priorities. Those people on that floor are the priorities. Sure. So to answer your question, what do we do with those PRA lists? Again, in the checklist, it says you should have that PRA list up to date. Because why? We may have changes in that list. Specifically, because we have more people within the home. We may or may not.
But what about whether they're infected or not? Is that even a relevant consideration for the purpose of a PRA list?
I think it is a relevant question, but according to right now in the province of Ontario, there is no direction to update the PRA list with anybody that has come down with COVID-19 or have been diagnosed or is under self-quarantine. But I can...
Go ahead.
Sorry, I can add one thing. There has been a public letter clarified or issued to the Ontario Fire Marshal's office as of, I think it was this evening, that requested clarification on that. And we're hoping to hear news from that. But yeah, really, I think by doing that, by adding them to the PRA list, let's face it, you know, when we already have 32 floor high-rise buildings with 8 PRAs on every floor in the building. So we have to understand that the drain on the fire services and the manpower to go and rescue all those PRAs would be difficult in the event that everybody on that floor or everybody in that building was a PRA. So the recommendation is, if the fire alarm goes off, even before that, the recommendation is every building owner should be taking the 4 or 5 pages from their approved fire safety plan and scanning them and sending to every occupant. And that says, follow these emergency procedures as they have been approved by the authority having jurisdiction and recognized throughout the province of Ontario. Once we get clarification, or if there are any changes to that PRA list, then at that time we can do that. But right now I don't see it as a positive move.
Unfortunately, I have to interrupt you, Jason Reed from the National Life Safety Group. We have to call you back. And we have to focus. I mean, tons of questions about the PRA list right now, tons of questions about the fire drills, tons of questions about, and so we'll have to call you back and maybe dedicate a portion of our webinar to that. But unfortunately, we got to move on. The train keeps moving forward. And so thank you very much, Jason. Now I'm going to ask you, Denise Lash from Lash Condo. Can you maybe, and I'm only going to give you 60 seconds.
60 seconds. Okay. I don't want to focus on meetings, but I want to say to everyone is don't worry about your AGMs. We have more important issues to deal with now. I realize that there's some corporations that need to hold meetings, perhaps if they lost the quorum of the board, but please don't rush into anything now. We expect there are going to be some changes. There was an emergency order issued by the Ontario government dealing with business corporations and not-for-profit corporations to allow virtual meetings. We expect that we're going to hear the same for condominium corporations, but we don't know how virtual meetings will work. There's also the integration of electronic voting with virtual meetings. So all I'm going to say right now is don't rush into anything. There have been questions about what's reasonable in terms of a delay. Until we have more information, you can know how to do a meeting properly virtually, or until it's safe to do one in person, just wait.
Okay, that's very useful, and do wait. I mean, I think right now what is clear is that in Ontario, meetings of more than 5 individuals together are not permissible, and so wait it out if it's at all possible. More information to come on this for sure, Denise. We're expecting that hopefully within a week, hopefully, finger crossed. Changing topics again, because we got to keep moving. Systematically, the questions that we keep getting are all about quarantine and self-isolation, and what do you do when you get a confirmed infected case? And we're getting those now. We're getting confirmed cases of infections in condos, and some involves employees, some involve occupants. And so a lot of the questions we get focus on that. Understandably, occupants are getting nervous, and I'm getting questions. I mean, the neighbor is ignoring self-quarantining. The neighbor just came back from Florida and she's walking her dog and she's touching door handles. And so, Graham, can you maybe give us an update or a recap on what does it mean? What does the Quarantine Act provide for? What are the federal, provincial, municipal restrictions that we're playing with now?
Yeah, absolutely. And so it has been confusing because there's been a lot of news lately and a lot of buzzwords that keep getting passed around. So we'll start with at the federal level. At the federal government, what they've done is under the Quarantine Act, they have implemented a rule that says that if you have been traveling outside of Canada, or if you've had close contact with someone who is or is suspected to have the COVID-19 virus, you must self-isolate for 14 days. And what this means is that you have to stay at home and you have to monitor your symptoms, even if they're mild, they're non-existent. You have to avoid contact with others as much as you can, and you have to practice physical and social distancing in your home and in your community. So for things like food, if you can order in, you should. For any other sorts of deliveries, it's just that. And then at the other level of government, at the provincial level, we've seen is different provinces, including Ontario, declaring an official state of emergency. And under that, it grants them the power to do things like, most recently, the Ontario government determined that for going forward for now, until we hear otherwise, that groups of 5 or more are now too big to be in. And if someone is breaching that, then there are fines that can be levied against them. And so what we're seeing at a municipal level then, when we go down the chain further, is that each municipality is tackling this in its own way. On each municipality's website, you can see the number you can call if you are aware that someone isn't respecting these social distancing rules. And what bylaw enforcement officials and what police are saying is that their preliminary goal with respect to when they get these calls or these reports is going to be to try and disperse any crowds that they see and try and educate people. But if it becomes more problematic, then we can see fines up to $100,000 and even imprisonment.
Right. So what's clear is that the police always have the power to enforce legislation, and certainly federal legislation such as the Quarantine Act. And so the Quarantine Act, as Graham just said, provides for quarantine, not self-isolation, quarantine in specific circumstances, as Graham just indicated. And so the police will be able to enforce that if required. Certainly in Ottawa, it's been confirmed, and I'm not sure if Denise, if you're able to speak to Toronto, but certainly in Ottawa, we've been advised that for sure, don't call 911, call the administrative number, but the police may be able to come to assist you with respect to quarantine, not self-isolation, not the fact that you think that this person, should be more circumspect in their walks. With respect to bylaw officers, certainly in Ottawa, again, what we have is that what they can enforce are the provincial regulations. As Graham just said, they'll break up a party of more than 5. They'll make sure that you're not playing in a public park. They'll make sure that your business is closed if it should be closed. So that's sort of for that. Denise, how do we deal with non-complying owners? That's a regular question we get. So somebody that's either not quarantining when they should or not self-isolating when they should. How do we deal with that?
Well, I wish I had the answer. You know, who will do something about it, and is it the corporation's role to do something about it? And using Jason's term, like to stay in our lanes, to stay in your lane. We're not public health officials. So as you said, if you know that somebody is not self-isolating, I had this issue with somebody who came back from New York and they were in the lobby. The manager didn't know what to do. You can try to call public health, bylaw officers, the police, but if they don't do anything, what can you do? And in this particular case, the manager sent a notice to that resident, telling that resident as to what their obligations are. Other than that, you know, they really couldn't do anything. If public health doesn't get involved, you just have to advise the resident that they should be self-isolating. And in this case, they cooperated.
Right. And a question we get often is often based on suspected sort of problems. The person is roaming and we suspect that she's back from Florida, and we think that perhaps what is clear, I think, right now is that someone that comes back from Florida or elsewhere and they're not showing symptoms and they haven't been found or tested to be positive, these people should sort of socially distance themselves. It doesn't mean that they can't go out for a walk. It does not mean that they can't walk their dogs. That's pretty clear. So one thing is self-distancing, and the other thing is if in fact you're infected, we're going to deal with that differently. So the fact that the poor lady seems like, you know, she's spending a lot of time roaming around, I keep hearing that. There's no social police yet. And to build on what Denise said, what I would do, I would react to those cases where we have a known infected person. That I'm more concerned with that. And if that was the case, and we have a couple of scenarios in a minute that maybe I'll save my some of my powder for those scenarios. But I would focus on those rather than the poor man or lady that came back from Florida and they're walking, pistached their dog, and you just feel that they're like lingering in the lobby or outside.
And Rod, can I just jump in here? Just talking about non-compliant owners, something that has come up is non-compliant residents with other kinds of protocols. So for example, we had a resident today, we have video evidence of them being in the elevator and sneezing on the elevator keys. And there was evidence that there was remnants, I'm not going to go into further details, all over the elevator, all elevator buttons. That particular resident didn't notify anyone, and they've discovered it on the video. So, you know, think about, and there was signage in the elevator all about appropriate protocols. Now think about what you do in that case. So we're running into those kinds of issues and possible chargeback for extra cleaning.
Right. Let's deal maybe with a scenario, 2 scenarios, and we'll see how we apply that to this. So the occupant of unit 306 advises that she's been confirmed as having contracted the virus. So she's tested, it's positive, she's got the virus. What precautions should the corporation take? Should you advise the owners? Should you restrict her movement? How do you deal with that? Do you want to take the first kick at the can, Denise?
Well, so if you know that this person has COVID-19,
right.
and well, first of all, you want to make sure the information is correct. You want to make sure it's not a rumor, because a lot of that has been going around. So if you can confirm that it is correct, what you want to do is not wait for public health. So public health may get in touch with you. That resident should be notified. as to what their responsibilities are, just in case they don't. All residents should be notified in any case, but another notice should go to that resident. And then perhaps public health would be in touch with the corporation, but they may not be. So what you don't want to do is wait. You want to send out notice right away to all the residents in the corporation and the owners advising that one of their residents has tested positive for COVID-19. And obviously you don't want to disclose who that person is, and you don't want to disclose where they're located.
Right, right. What we've done in cases like this is this. So the person themselves, they come forward, they say, well, you know, I'm infected and I'm going to do my best, I'm going to stay in my unit. We send a notice to the collective owners, to everybody. Now, obviously, we don't identify the person. We don't even identify the floor. But we send a notice to all the owners to advise them that there is a case in the community. And we make it clear why we can't provide more details, but we invite them to be far more careful. And we also reassure them with the precautions that we've taken with respect to that. That's the first letter. The second letter, we send it to the individual who who's infected. And we actually make it quite clear what's expected of these individuals. And we make it quite clear that in those circumstances, they are not to leave the unit. They are not to roam around. They are not to go check their mail. They are not to go to the garbage chute. And they are to take steps to ensure that whatever they need, the deliveries or garbage pickup or mail delivery or whatever it is, it's up to them to ensure that that's provided by somebody else, because they are not. They're simply, that's the position we take anyways. They're not to go in the hallways. And we make it quite clear, actually, and we refer them to the various sort of provisions of legislation. We want to be able to later on say, listen, we did everything we could, short of putting an electric ankle bracelet around them. We did it, which we would not do. Don't get excited. But we did everything we could. So we've warned people, we told them to be more careful, and we told this person, you shall not do this. And we think that on the basis of that letter, if that person was to ignore this, we would be able to enforce the same way you enforce the breach to any rule. To us, someone that would continue to behave in such a way as to put the community in danger, that would constitute an infraction under Section 117. It's a dangerous conduct. It's a conduct that it's at risk of causing an injury. And so that's how we would tackle it. I don't know if the managers, how do you deal with this? And I also would like to hear if Jason has to say something about that, but maybe managers first, Sandy or Catherine, how do you deal with the known case of infected unit 306?
I want to step back for just a couple of moments. Good guidance at this point in time, given everything we know about the numbers of confirmed cases that we are starting to see. In multi-residential settings, everybody who is in a condominium should govern themselves and the physical distancing and all of the cleaning and sanitation is as if you know that there's a confirmed case already in your building. What is happening now, what the guidance is, when I look at public health sites, is people who have returned from travel, people who are symptomatic, they're not being told to go to a doctor's office or a hospital. They're asked to take a self-assessment tool, and they're asked to stay at home. Insofar as a condominium corporation can try to encourage reports so that we can act responsibly and help somebody effectively self-isolate, I think that's where we'll be most effective in stemming any transmission within the community. I'm really concerned about comments that people are making about back charging cleaning and sanitation. And one of the reasons why I'm concerned, I hear you when it comes to somebody who is acting really, like deliberately, egregiously, right? So you know that you have a case of COVID, you've been tested and diagnosed positive, and you're kind of trying to give it to everybody by licking doorknobs. Well, that's a very different thing. Right? Right. What I'm really concerned about is that we encourage good behavior, right? We encourage caremongering instead of scaremongering. And I have amazing residents in the buildings that I work with who have stepped up and put together some volunteer committees so that they can help people effectively self-isolate. And I think that's our best way forward. People are not trying to catch COVID, not by a long shot. And I want to be able to support them insofar as we're able.
Right. Okay. Now, I think we've managed to already ignore what Graham told us with respect to what's self-isolation, what's self-quarantine. It's so confusing. I'm confused already. Graham, can you just shed quickly some light on that?
Yeah, so I think the easier way to think about it is there's 3 levels at which the federal government has defined what you can be doing. At the bottom and least restrictive level is what's called social distancing, and that's what everybody's doing. We're avoiding crowds, we're not shaking hands, and we're staying 2 meters away from everyone, and we're not going into any sort of situation where there's people around unless it's essential. The next level, and I think this is where a lot of the confusion comes from, is quarantining slash self-isolating. And that's confusing because the federal government has actually defined the two as one and the same. So quarantining or self-isolating is what you have to do if you've been traveling outside of Canada and you've come back. This means that you have to stay in your house for 14 days and only leave it if it is essential. And then the final level, the most restrictive, and I think, paradoxically, they've named it the way they have. The final and most restrictive level is just called isolation, which means go home immediately, don't stop anywhere, and stay there. And so that's reserved for cases where someone's been traveling abroad and they return and they have symptoms, or if they're a confirmed positive case. So again, the 3 levels are at the bottom, the least restrictive, which is what everybody is trying to do right now, is social distancing. On top of that is mandatory self-isolation / quarantine. And then on top of that is isolation.
Okay.
I wish that it had been named better. We didn't name them, but those are the terms we're working with.
Okay. Jason Reed from National Life Safety Group, did you have anything to add to this? I'm not sure. Oh, you're muted. No. Wait a second.
Can you hear me now?
Yeah.
Yeah, I think it's vitally important if the condo board is aware of somebody that is in self-isolation or quarantine. It doesn't really matter to me. And you see them outside and there is a health and safety concern, I think it's vitally important that you have to communicate that. And whether it's confirmed or not, you're communicating it back and you're advising them what a security guard or concierge would do about a boy playing skateboarding on the driveway where they're not supposed to, where they could potentially get hurt or hurt somebody else. So I think it's just a very simple way to approach it. Yes.
Oh my goodness, I can't believe it's already been an hour. Let's just dive into the next, thank you so much, Jason. Let's dive into the next scenario. I'm gonna change, rather than have an owner that's infected, we're gonna deal with an employee that's infected and whether or not that changed anything. So you just found out that your valet parking employee, or one of them, came forward and said, listen, I was tested positive, and of course he or she's gonna stay home. But are we concerned about the impact that they may have had on the community? He or she has been sitting in everybody's cars, and so how do we deal with this? Denise, do you want to take the first kick at the can here?
Yeah, I want to, because this was a question that was posed from an attorney in Florida who actually had to deal with this, and I'm not sure what happened in the end. There were 2 options. One is to advise all the residents about the valet. And by doing that, the privacy of that individual obviously can't be kept private. Everybody will know. So that was the issue and the concern by the attorney. The other option they were looking at is looking at the video footage and seeing over a certain period of time who that valet came into contact with and what cars. And then they were going to wash those cars and contact the residents whose cars may have been impacted by that infected valet. So there were a couple of options, and I think that's what we're seeing here, is that what is the correct answer? But forget about the privacy, perhaps, of that individual.
Right. Maybe one of the 2 managers.
So I think this is where some pre-planning comes into play. I'm very grateful that those that I'm aware of with Valet have stopped that service to residents in an abundance of caution in order to avoid just exactly this type of a problem or a consideration. If you were to have that situation as a property manager, you'd be consulting with your solicitor. And that's because if you were going to breach your duty and covenant of privacy to an employee, you would want to have a legal opinion before your board did that. I, again, would want to make sure that we can inform our residents, make sure that they take the appropriate actions. That isn't my point. But I also want to make sure that we're doing it responsibly, that we aren't inciting panic, and that we are rolling with an appropriate plan for how we're going to address it.
Yeah. What about advising individuals, though, specifically? Because I think of what Via Rail did a couple of weeks ago, and they basically said, well, we had an employee, he was infected, he was last on the train on March 18, he was on train 34, 46, and 65 on that date. And there's a reason for that. And the reason for that is you want people to be able to you know, self-isolate or be more careful. Because otherwise, if I was on that train, well, you know, I may react differently. I may take extra precautions. So how do we deal with that? Jason, did you have something to say about that when we were discussing this earlier on?
Listen, I think you have an obligation to inform everybody in the building that there has been or there may be a potential exposure. You know, I put myself in that shoes. It allows me to sit there and say, geez, you know what? I was in that, they used my car. Geez, okay, they're going to clean it. That's nice of them. What do I need to do to make sure I can go see my grandmother later tonight? Or maybe I don't see my grandmother later tonight. I think the point here is by informing me, you allow me to make judgment calls because of that information. It's not a lot of information, but it's what you know. I'm not suggesting give away private details of the name and resident location. But if I would provide an argument that if I would have known, I wouldn't have gone to see my sick grandmother. I would have stopped seeing my mother and brought her groceries. And I must be afforded that information, in my view.
Right. Okay.
Rod, can I just mention we had the same issue with a super who came in contact with a resident who had COVID-19. And in that case, management did advise the residents that the super had been in contact. So that information was not kept confidential. I mean, we're weighing the two, privacy versus the health and safety of the residents.
Right.
I can make one final comment, and again, it's always in deference to what the public health recommendation is. And at present, I'm not entirely clear on what is meant by close contact. But one of the questions that was floating around in the chat related to this issue has to do with if you were to have a confirmed case like that, whether or not the balance of folks who worked with that superintendent, for instance, would need to self-isolate. And I might recommend that you get in touch with public health so that you can get good guidance as a property manager for your staff, and so that you can understand better what the recommendation in Toronto is currently, and that is if they've had close contact, that they would self-isolate. And again, I don't know whether, if they've practiced social distancing for the last 2 weeks or more, whether that's considered to be satisfactory or not.
Okay. Very useful. Sandy, anything to add? Or
No,
do we move on?
No, we can move on.
Wonderful. Thanks so much. Okay, so now last scenario, and this leads us into the sort of recurring questions at the same time, and it brings us closer to the conclusion of this program. This is the third scenario. The province is asking people over the age of 70 to stay home. So if you're over 70 years old, you should stay in your unit. You shouldn't go out. You shouldn't go to the groceries. Similarly, those who are infected or those who have traveled recently are, told to stay home to the extent possible. How do we ensure that these people have access to what they need: groceries, medication, mail, etc.? And maybe part of the answer is it's really not the corporation's problem. And maybe that's the answer. I mean, ultimately, the corporation is there to manage assets. We manage brick and mortar. But so how do we tackle that? Maybe I'm going to start with Sandy. How do you tackle that?
Well, neighbor to neighbor groups are a good way for, for condos to get around some of this. Your security don't necessarily have the time to be going up and down and running mail and running deliveries to their residents, but, neighbors who are healthy certainly can help out in that regard. In regards to picking up mail, if a resident's gone away for a couple of weeks, they've left their mail for 2 weeks. So if they're home and they're in quarantine or self-isolation for 2 weeks, they really probably don't need their mail during that period of time either. Dog walkers are essential for these people who are self-isolating. These dog walkers do need to come into the building, and a self-isolating or a quarantine person cannot bring their dogs down. So the dog walker does need to make those arrangements to go up. So those are the realities that the high rises do need to deal with.
Okay. And what about deliveries, be it food or Uber Eats or medication or whatever it is? How do we tackle that on the grounds? I'm not sure if it's Sandy or Catherine that's going to tackle this one.
I think that was mine to take, but
Yep.
if I'm wrong, Sandy, let
Go
me
ahead.
know.
Go ahead.
Once again, you've got to weigh some of the risks that are involved in what your staff and staffing levels are. So you've got an obligation to make sure that any of your staff members, whether they're in-house or contracted, can suitably protect themselves. The other thing that you're going to need to set up, if you're going to go kind of depot style, is a way in which folks can be reminded of social distancing requirements these days. Those deliveries, however, are essential in making sure that folks can stay home and stay healthy, whether it's because they're medically sensitive or because they are quarantined. As time goes by, we might need to think about enabling all of these functions with a reduced staff. And so, take a look at how, an owner could let somebody in through an interphone, for instance, as opposed to having a staff member who's going to handle all of those deliveries.
Mm-hmm, mm-hmm. Graham, maybe if you can give us maybe the 3 schools of thought on deliveries, a recap on that.
Yeah, absolutely. So there's a couple of different thoughts on what the most effective way to deal with deliveries right now is. And I think the answer is that there's no clear one-size-fits-all answer, and it's going to be a decision that's made at the board level depending on the circumstances of the building in particular. So on the one hand, the thought is that maybe we should have deliveries go, where possible, all the way to the units, knock on the door and do it there. The other school of thought is, shouldn't deliveries just stop at the lobby door because that avoids new people coming into the building? The downside with that issue, though, is that at peak times, like around now, when people are going to be ordering dinner, it can result in a situation where multiple people are in the lobby at the same time. So I mean, to be blunt about it, I think with that, it's just kind of how do you want to get it wrong, and what measures can you put in place to make sure that you are minimizing the risk, and that's just going to, I think, depend on the circumstances of the building and what the owners are looking for.
Okay. If we are, if somebody's in quarantine, like real full-blown lockdown quarantine, Catherine, what about garbage?
It's something that you're going to need to discuss with staff, because you're going to need to make sure that your staff members feel comfortable in how you're handling or managing garbage. So, if it's possible for them to leave the garbage outside in the hallway and have it picked up, and that's something that you have the staff for and you have the protective personal equipment for, you don't, of course, want them traveling through the hallways and entering into the garbage chute room. The other thing that's possible, and it sounds terrible, but in Toronto in particular, we lived through it when we had a garbage strike. And we asked people to hold on to their garbage if another arrangement couldn't be made. We asked them to keep it in their fridge or in their freezer. And I'm not saying that that's a great option for today, but as we start to look at the potential for having more and more diagnosed cases and a potential for having less and less staff, I think we have to be pragmatic about the directions we're giving to homeowners. And I think we have to prepare in our minds what is going to be the safest circumstance for everybody involved. And I love my communities who have really good caring networks involved, and folks who, are willing at this point in time to participate in, picking up the garbage from their neighbor who leaves it outside at 10 o'clock in the morning because they're walking down the hall as well. But as time goes by and more people have diagnosed cases, you may or may not have quite the same number of willing participants. I hope we will. Canadians are amazing like that, but we need to also prepare for when we don't have those circumstances.
Right, and with respect to these volunteers, my concern often is if it's organized or supported or advanced or condoned by the corporation, we're sort of getting involved now. And if there's any risks associated with that, if anybody's going to get infected because they were the kind soul that decided they would pick up the garbage or whatever it is, there may be a bit of risk associated with that. And so in a perfect scenario, you take a more passive approach as a corporation. I mean, if you have neighbors that want to organize that and they're prepared to go help Judith in Unit 306, that's great. That's on them, and that's fantastic. And it should be encouraged. But if we sort of now become the overseer of that undertaking, if the corporation becomes the overseer, to me, there's a potential risk associated with that. You'd want to make sure that people walk in there with their eyes wide open. You'd want to make sure that you provide them with all sorts of information, as if we didn't have enough of that right now, about precautions to be taken. And in some instances, you may even want to consider either sort of imposing a waiver, even if it's just the way you set it up and you say, okay, well, if you sign up for this, you accept X, Y, Z. And you're doing it at your own risk and you understand the risk and this and that and the other. And if you don't want to play by these rules, don't put your name on this list. So that's like the sort of self-imposed waiver that I think it's at least a precaution you took. Or you may want to get a full-blown waiver, but that is becoming maybe overly legalistic. I don't know, Denise from...
Yeah, I'm not sure I agree with you on that one, Rod, because I had this question and our advice is you don't want to get involved to that extent. I mean, you can sort of facilitate, but by getting a waiver, what you're saying is, you know, we may be liable, but, you know, you're going to waive your rights to pursue any claims against us. So I want to distance the corporation from these groups.
Right. I think on that, you and we agree, actually, that that's the preferred approach, is to have as much distance as possible between the corporation and those groups. I agree with you. And I guess the waiver or the warnings were more if for whatever reason you do get involved. But I agree with you, Denise, that it's probably best not to be involved in it.
I'm glad you agree with me, Rod. Thank you.
Well, that's why you're on the panel. No, thank you so much, everybody. I think this is pretty much what we had on the agenda, and we sort of spilled over by nearly 15 minutes. And what I'm going to do is I'm going to do my usual sort of last round to see if anybody has anything to add, or a topic or a question that they want to address. Or if not, just words of wisdom. So I'm going to start by thanking Sandy Folds of Wilson Blanchard Management. Any sort of topic you want to conclude on, or?
Sure. We just need to keep stressing to our residents that they need to remain calm through these uncertain times. Stay home, practice physical distancing, and if you absolutely have to go out, keep washing those hands.
Thank you. Catherine Gow from for ACMO, the Association of Condo Managers of Ontario. Any parting words of wisdom?
I have one, and it has to do with two things that I think twice we may have glossed over a tiny bit. And one is open houses, and even realtors are not encouraging open houses any longer. A week or two ago, Graham had mentioned that, if I'm not mistaken, it was Graham, there are amazing, virtual tools and things of that nature that are available. That being said, I think a showing in Ontario, at least as of the recording of this particular webinar, it is considered still essential, which means I don't know that you could prevent somebody who was at by appointment making showings of a suite possible. The second is move-ins. You can't stop somebody from moving into their property, and in particular if they don't have another one to live in after a certain date and time. Of all of the controlled entries into a condominium these days, that might be the easiest. You've got a clear path, you've got an elevator that's dedicated for that service, and there's an opportunity to clean or sanitize afterwards. And that's something that can be planned for and arranged for and organized for. One of the questions through the chat had to do with a move that involved international travel. And I think the governance on that is clear, and it's not unlike the required self-isolation that Graham had spoken of previously. Otherwise, keep calm, wash your hands, sanitize your cell phone. We'll all get through this together. And I want to thank everybody in Condoland for all of their patience, all of their pragmatic tips and tools, and all of their assistance to each other.
Thank you so much. I'm glad you brought up the open houses because that was a recurring question. So now I'm going to turn the microphone to Denise Lash from Lash Condo Law and speaking also on behalf of CAI. Denise.
Yeah, I mean, I think this is great what you've done, Rod. There's so much information and there's so many questions now on chat. We will get to them next time. Something we really didn't talk about were visitors to condominium corporations, because a lot of corporations are taking different approaches. Right now, I don't see how corporations can restrict visitors. Social gatherings, we know of five or more, but people coming into condos, there may be a reason why somebody doesn't want to disclose why they have someone coming to see them. It may be a mental health issue. So just be careful if you develop those procedures. As of today, things may change tomorrow.
Right, very good. Denise, also for those of you who don't know, has an amazing blog on her website, a condo blog, Lash Condo Law. So if you're looking for your second favorite blog, that's the one you should pick. Graham McPherson from Gowling WLG, words of wisdom.
Yeah, I guess I'll just say that less wise, more just kind of hopeful and thankful that I understand that this social distancing is tough. It's been tough on everyone. So I just want to say to everybody in the chat and everybody who's here, thank you for doing all that you have been doing. We understand that this is very inconvenient and tough, but what you're doing matters. And if we just keep it up and stay strong, we can hopefully contain this as much as possible.
Wonderful. Thanks so much. David Plotkin from Gowling WLG.
Thanks, Rod. I'm just going to continue on the theme that I always end with on being reasonable. And this is me actually taking off my condo lawyer and litigator hat because we often, our services are often required when one or more parties choose not to be reasonable. But I think we're now all living in a very human world, a situation where we just need to do the best we can to put those, petty issues or borderline issues to the side, just like our courts are doing. Our courts are really being stringent on only hearing the most urgent issues. And I've been keeping a look on the case law, and they're throwing out cases left and right and saying, come back to us in 3 months. We don't want to hear from you. We don't care if you think it's urgent. It's not. So let's really be conscious of picking our battles and really just being reasonable as best we can.
Okay, wonderful. Jason Reed from the National Life Safety Group. Thank you so much. And any words of wisdom?
Yeah, listen, thank you for allowing me to be here. I think building managers deserve a huge thank you. They're on the front line. They deserve to be paid more. They've been asked to do more with less. The immediate takeaway I have is the great work that you've done and your boards and a lot of people making decisions based on, feedback from their teams, best practices, a variance of reasoning to make those decisions. I ask that you document some of them. In 6 to 12 months or 18 months, potentially you may be asked to recall some of those details or let somebody know when you did that and made that decision. So I encourage you to document it, whether it's on our template or any template. But that's something I think is going to be a lesson learned 12 months from now. And I'd like you all to be prepared for it.
Crucially important piece of advice there. Thank you, Jason. Justin Tudor, Keller Engineering, words of wisdom?
Yeah, thanks for having me. Everything's messed up with constant uncertainty and changes. So many plans that we're seeing are based on waiting to see what tomorrow looks like, and that's entirely garbage. It's kind of like what Denise said. Have a plan that's based on your long-term outlook and adapt it when you see what tomorrow brings, but don't wait to see what tomorrow looks like. Thanks.
Thank you so very much. Okay, everybody. Thanks for everybody that's still on the line. We've lost a few players, but that's okay. The next webinar next week is Passover on Thursday, if I'm not mistaken, and the celebrations on Wednesday as well. So we're going to exceptionally reconvene on Tuesday night, April 7th at 5. So Tuesday as opposed to Wednesday. If you're looking for information about our next webinar, you can find that if you go on my blog, condoadvisor.ca. We've added a tab at the top right, webinars. There you will see the next webinar. You'll also see how to register for it, and you'll also see past webinars. We've finally been able to upload the first webinar. Took us a while to figure things out, but we're now uploading them. And so if you missed an episode, or if you want to entertain your kids tomorrow while you're trying to work, you can put them in front of the screen and have them become condo experts. So that's it for me as well. I'm going to sort of echo what everybody else said. I think those are interesting times. Fasten your seatbelts, put your table in the upright position because they may get a little bumpy, but we're all going to come through this together. Be safe, be healthy, be good to one another, and see you next week. Thanks very much to the panelists and to everybody at home. Thanks so much. Take care.
Everybody.